In the first week of April, YouTubers filed class action lawsuits against Apple and Amazon, accusing both companies of illegally scraping their videos from YouTube to train AI models. These lawsuits follow identical suits against Snap, NVIDIA, Meta, and ByteDance, all filed by the same group of creators. And the legal strategy they're using is not what you'd expect. These creators are not arguing fair use. They're not even arguing traditional copyright infringement. They're using a completely different section of law. And if it works, it could change how every AI company in the world collects training data. Let me break it down. A quick reminder, everything I share on this channel is legal information and commentary, not legal advice. If you need guidance specific to your situation, please consult a licensed attorney in your jurisdiction. With that being said, let's get into it. The Plaintiffs are a group of YouTube creators. TED Entertainment, which is the company behind H3H3 Productions, with over 5.5 million subscribers, along with Mr. Short Game Golf and Golfaholics. Together, they represent about 6.2 million subscribers, and they've been on a legal campaign. In December 2025, they sued NVIDIA. In January 2026, they added Meta and ByteDance and Snap. And in the first week of April 2026, they filed new lawsuits against Apple and Amazon. That's 7 major tech companies targeted by the same group of creators with the same legal theory. The core allegation is the same in every case. These companies scraped millions of YouTube videos without permission to train their AI models. The Snap lawsuit specifically calls out 2 datasets, one of which contains information about millions of YouTube videos, and the other a collection of 3.8 million YouTube videos split into roughly 70 million clips. Both datasets were created for academic research purposes only. Both carry explicit non-commercial use restrictions, and the plaintiffs allege that these companies use them commercially to build products like Snap's Imagine Lens, Apple's video generation models, and Amazon's NovaReel. Here is where this gets really interesting from a legal perspective. In most AI copyright lawsuits, the fight is about fair use. AI companies argue that training a model on copyrighted content is transformative. They're not copying your video, they're learning patterns from it. And in some cases, courts have actually been receptive to that argument. A judge sided with Meta against a group of authors using exactly that fair use defense. But these YouTubers took a different path. Instead of arguing about whether AI training is fair use, which is a complicated, fact-intensive question that courts are still navigating when it comes to AI, they went after how the data was obtained in the first place. Their lawsuits are built on the DMCA Section 1201, the Anti-Circumvention provision of the Digital Millennium Copyright Act. Section 1201 prohibits bypassing technological protection measures, or TPMs, that copyright holders put in place to restrict access to their work. The argument the YouTubers are making is this: YouTube has technical systems in place that prevent bulk downloading and scraping of videos. You can watch a video on YouTube, but YouTube's architecture is designed to prevent a user from downloading the actual video files at scale. These systems, the controlled streaming architecture, the access controls, the terms of service that prohibit scraping, are technological protection measures under the Digital Millennium Copyright Act. The plaintiffs allege that these companies deliberately bypass those protections. According to the Amazon lawsuit specifically, the company used virtual machines, rotating IP addresses, and automated tools to download videos while avoiding detection. That's not just downloading a video. That is circumventing the protections YouTube has in place to prevent exactly that type of conduct. This legal strategy that the YouTubers are taking is significant for 2 reasons. First, it sidesteps the fair use debate entirely. Fair use is messy. It's a 4-factor balancing test. It's decided case by case, and AI companies have had some success arguing that training is transformative. But the DMCA Section 1201 is different. The question isn't whether the use of the content was fair. The question is whether the company broke through technical barriers to access it. If you bypassed YouTube's protections to download videos, that's a potential DMCA violation, regardless of what you did with the video after the fact. Second, the statutory damages under Section 1201 are significant. For willful copyright infringement, damages can range up to $150,000 per work. When you're talking about millions of videos, the potential exposure here is enormous, and the plaintiffs don't have to prove how much money they lost. Statutory damages are set by the statute, not by the actual harm. This is why the same group of creators is filing the same type of lawsuit against company after company. They've found a legal theory that avoids the strongest AI defense argument, fair use, and attacks the weakest point in the AI training pipeline. How was the data collected? These lawsuits don't exist in isolation. According to the Copyright Alliance, over 100 copyright infringement cases have now been filed against AI companies in the United States. The New York Times is suing OpenAI and Microsoft. Encyclopedia Britannica and Merriam-Webster sued OpenAI in March 2026. Reddit has filed suit against data scrapers. Musicians, authors, visual artists, and publishers are all in court over very similar issues. The outcomes so far, though, are mixed. Some courts have been receptive to fair use defenses for AI training. A judge dismissed authors' claims against Meta. But other cases have survived early motions and are heading to discovery. But no single case has definitively answered the question whether AI training on copyrighted content is legal. The Section 1201 strategy adds a new front. Even if courts eventually decide that training AI on copyrighted work is fair use, the question of how the content was obtained is a separate matter entirely. If companies circumvented technical protections to access that content, that's a distinct violation. You can't break into a library and then argue you were just reading books. There would still be the crime of breaking into the library, regardless of why you did it. While these cases are working through the courts, Congress is also responding. The No Fakes Act, which stands for Nurture Originals, Foster Art, and Keep Entertainment Safe, has been introduced in both the House and the Senate. It would create the first federal right of publicity in the United States, protecting individuals' voices and visual likenesses from unauthorized AI-generated replicas. The No Fakes Act has not been signed into law yet. It's still working its way through Congress, but it has bipartisan support and backing from the Recording Academy, the Recording Industry Association of America, SAG-AFTRA, and notably, both YouTube and OpenAI. At the state level, there's also movement. States like Tennessee and Delaware have been advancing legislation targeting unauthorized AI replicas, particularly in professional contexts like healthcare. The patchwork of state and federal activity all point in the same direction. Creators' rights in the AI era are becoming a legislative priority. If you post video content on YouTube or any other platform, this story matters for you, and here's why. Your videos may already be in an AI training data set. One of the data sets in question for this case alone contains 3.8 million YouTube videos across 48,000 channels. A Proof News investigation found that creators like Mr. Beast, Marquise Brownlee, and PewDiePie all had their content included. You don't need to be a major creator to be affected. These data sets are massive and indiscriminate. And once your content is in a training data set, the plaintiffs in the Amazon lawsuit put it bluntly. Once AI ingests content, that content is stored in its neural network and it is not capable of deletion or retraction. The damage is permanent. These lawsuits are the first time creators have found a legal strategy that appears to have real traction against tech companies who are scraping their work. Whether these cases ultimately succeed is still an open question. This is the early stages of litigation. But the fact that the same creators are scaling this strategy across 7 different companies suggests they believe the legal theory is a strong one. For creators, right now, the most important thing you can do is register your copyrights. I've said this before, and I'm going to keep saying it. Copyright registration costs $65 at copyright.gov, and it gives you access to statutory damages and attorney's fees if you have to enforce your copyright. Tools that you don't have without registration. If your content is ever scraped for AI training, registration of your copyright is what gives you meaningful legal remedies. Here's my take. The shift from fair use arguments to DMCA anti-circumvention is the most important legal development in AI copyright space right now. Fair use has been a shield for AI companies. This strategy attacks the shield by asking a different question. It doesn't matter if the use was fair if you broke the law to get the content in the first place. It also matters that these lawsuits are coming from creators, not just publishers and corporations. When the New York Times sues OpenAI, that's one media giant versus another. But when 3 YouTubers representing a class of independent creators sue Apple and Amazon, that's the kind of case that changes how the industry thinks about creator rights. This story is evolving fast. If you want to understand how the law is shaping the future of AI and creator rights, subscribe. This is exactly what Girl Code of Law is here for. I'm Stevie. This is Girl Code of Law. I'll see you next week.